The Finance Administration Committee meeting to order. Start out the meeting with public comment. Is there any public comment?
Good morning.
Honor.
Good morning. I'm John Van Allsburg from Park Township. I'm also Chief Judge of the 20th Circuit Court, and I came here to talk about item 8 on your agenda, which I apologize in advance. I will not be able to stay around for. I have to head off to Lansing after public comment this morning. But our trial court administrator, Susan Franklin, and our trial division director, Cheryl Zorn, will be remaining. And if you have any questions, they'd be happy to answer those for you. The wage study that was done by the county over the past year resulted in a number of post-study appeals, and the 20th Circuit and Probate Court appealed 13 of those positions, 6 in the trial division, 4 in the probate court, 3 in the friend of the court. One of those appeals was granted. The probate clerk position was moved from pay grade 2 to pay grade 3. Judge Fine and I, as chief judges, approved every one of those appeals, and we consider them all to have merit. But I wanted to bring one specifically to your attention, that of the circuit court clerks. There are 3 that are affected by the denial of the adjustment to the pay grade. And all 3 of these clerks are the personal judicial assistants to the circuit court judges. And so I've been asked by my colleagues to speak to this issue. As the chief judge, I am the statutory hiring and firing authority for every employee of the court system. Although I do not set pay, obviously, but I have the authority to hire and fire with 2 exceptions. Obviously, I can't hire or fire my own colleagues who were elected by the voters. And also, I cannot hire or fire any of their secretaries. Each judge has that authority over his or her own judicial assistant. And these are the positions that I'm talking about here today. We work closely with our judicial assistants. They report to their assigned judge and to the trial court director. And they're responsible for the judge's calendar, for scheduling all cases, for organizing files for trials, hearings, and other matters. They also deal directly with the public on behalf of the judge in all cases. They deal with members of the bar and with members of other county agencies. They prepare court orders, judicial correspondence, and they monitor our court hearings. They're the ones contacting the sheriff if something goes wrong in the courtroom. They have a lot of responsibility. And since the pandemic began 2.5 years ago, their duties have increased. They have had to learn how to arrange and monitor and operate Zoom hearings in the courtroom. They assist the court and the litigants and the attorneys with technology and presentation issues. They send Zoom information along with notices of hearing and trials to parties and to their attorneys. And they have to receive and print and compile proposed exhibits, which are now sent electronically to them by attorneys and by litigants. And frankly, these amount to dozens of exhibits per week, amounting to hundreds of pages. And so their job duties have increased in the last couple of years pretty significantly. As you may know, we have a 5th Circuit judge on the ballot this year that the legislature created and the county agreed to fund. And so we will have another one of these positions created. But there are 3 judicial secretaries right now who have been with the court for many years and who have reached the top step in the current pay grade. And so as a result, their pay is frozen. They are not eligible for cost of living increases. And frankly, we're at risk of losing them. There would have been 4, but we had 1 retirement this year after the wage study came out and their pay was frozen. But we do not want to lose our judicial assistants. They're well-trained, they're skilled, we have good relationships with them, and the operation of the court would be negatively affected if we had to replace our personal secretaries. And so I am appealing to you to make a recommendation to the full county commission to increase the pay grade of the court clerks from grade 4 to grade 7, and allow us to keep our judicial secretaries. So that was the comment I wanted to make. I appreciate your consideration of that request. And if you have any questions, I'll take those now. or I'll leave those for our administrator and trial division director.
Thank you, John. Any questions for John? No? Thank you, sir.
All right, thank you.
Have a safe trip to Lansing. Any other public comment? Seeing none, I entertain a motion for the consent items, the approval of the agenda and approval of the last meeting's minutes. So moved. Or
Mr. Chair,
Yes,
just,
sir.
I'm sorry, just on that, the number may have been already amended, but there was a number 4, purchase of developmental rights program scoring criteria. That was put on this agenda in error, and it was discussed at the Planning and Policy Committee meeting.
Oh,
So
okay.
you can remove number 4, the purchase of development rights program scoring criteria.
Okay.
The only amendment.
Thank you.
Wait a minute, number 4?
You already have a new copy.
Oh, is it off the agenda? Did they already? Okay. So
There's-
I don't see it on the agenda.
There's updated, you have an updated copy.
I have an updated one.
all right, then I stand
All right.
corrected. I have an old one. Just
All right.
making sure it's not on there.
Thank you. Any other comments, additions? All in favor, say aye. All opposed, same sign. Motion passes. Need a motion for the statement of review.
So moved. Second.
Questions, comments? All in favor, say aye.
Aye.
All opposed, same sign. Motion passes. Need a motion for the 2022 Ottawa County Apportionment Report.
So moved.
Questions, comments? Brian?
Morning, everyone. I actually have 2 things that I would like to ask of you today. The first is just to approve the report. I'll give you a little brief background about how the report is developed. Our office sends out draft versions of what the levying entities are allowed to levy around the county. These levying entities then return these forms to our office, and then we review and audit them and make sure that they are in compliant, they're levying what they're allowed to levy. That we take that information and we compile it into the form, which you see, I think it's starting on page 4 in your book. So it's actually those first 4 pages that you're approving. The rest of the documentation in the report is simply displaying the information in a format that's beneficial to others around the state. So that's the first thing that I'm requesting you approve. The second thing is that this report, while it is accurate today, is likely to be inaccurate following the November election. And so what I'm asking is that we approve the report as submitted now, but letting you know that after the November election, there are 3 measures that are on the ballot, which if they approve, will need to be amended within this report. And because of the timing between the November election and our next finance committee meeting, there's not enough time in there to go to this before this body. So I'm requesting that we're able to bypass the finance committee and go directly to the Board of Commissioners with the amended report in November.
Questions of Brian?
The changes are because of potential.
So there are 3 items that are on the ballot. Yep. The first is in Olive Township. They placed a road millage on the ballot. And just because of the politics at the time, that road millage did not pass. But they expect that it will in November. So they put it back on the ballot in November. That was the first one. Ravenna Schools desired to put an override on the ballot, and they missed the filing deadline for the summer ballot. So they had to push that back then to the November ballot. And then Blenheim Township decided they wanted to add a road millage. I don't have a crystal ball. I can't say if they will pass, but likely all 3 of them will. So if none of them pass, then this is a moot point and I won't be back in November, but likely at least one of them will pass and this will need to be amended.
Okay, thanks. Good. Thank you.
Very good. Thank you.
All in favor, say aye.
Aye.
All opposed, same sign. Motion passes. Need a motion for the fiscal year 23 agreement for MSU Extension Services.
So moved.
Or
John?
this is a renewal of our agreement with MSU Extension. Aaron Moore's here. Total cost is about $264,000. Last year's cost was about $257,000.
If this is our standard annual memorandum of agreement for extension services, the contract remains the same. It did represent a 3% increase from last year's contract. Essentially, it covers 4-H program coordination, small fruit education, and environmental quality, as well as office support. In return, we provide nutrition education, beginner farming and farm business education, agriculture education across Christmas tree, dairy, nursery, greenhouse, and financial literacy, in addition to health programming. And that sort of encompasses the agreement.
Thank you. Any questions for Aaron? Thank you very much.
Thank you.
All in favor, say aye. Aye. All opposed, same sign. Motion passes. Need a motion for the approval for travel outside of the contiguous 48 states. So. Or. John,
When someone travels outside of the 48 contiguous state, the travel policy asks that be approved by the finance committee. This travel CMH, it's a specific annual conference that is only available, is the only place available to get this type of learning. And it is fully funded by a grant, but we did want to bring it to the finance committee for approval. The travel, it was brought up just as the agenda was being finalized. So that I think he is actually en route, or the training is happening right now.
questions? All in favor, say aye.
Aye.
All opposed, same sign. Motion passes. In a motion for the parks personnel request. Support. Jason or Marcy or?
Thank you. This is a realignment. So it's consolidating our communications and our programming, interpretive services. And I guess the best example is we call our nature education center our visitor center. So it's really aligning those two together in one department, communications, what I call community engagement. So no better way to tell the story of what we're doing than through our programming. You all had a pretty robust conversation about the newsletter. Our newsletter goes out quarterly as well. It includes lots of programming, but all of our information. So it's really trying to consolidate both of those under one coordinator.
Questions? Thank you, Jason.
Thank you.
All in favor, say aye. Aye. All opposed, same sign. Motion passes. In a motion for the clerk register of deeds personnel request. So moved.
Second.
Justin, did you want? Justin? Tell us again why you need this.
Yeah. Gentlemen, thank you. Yeah, we recognize this is a big deal. It's a big deal for our department. The biggest reason is transparency. Honestly, when it comes right down to it. Our team, we did a time study in June of this year. Our team is spending 25% of our election staffing time currently on the 2020 cycle. And so this has been a big impact for us. A lot of that comes through the Freedom of Information Act requests piece of it, but it's also a lot of communication and voter contact as well. On average, in the 5 years previous to 2020, we received about 8 FOIAs a year. And those are handled obviously by the election team. This year, we're at well over 100. And a lot of those FOIAs are what I would call kind of copy and paste type FOIAs that are coming from national entities. And that, either residents of Ottawa County, in many cases is not residents of Ottawa County. We're just sort of submitting these FOIA requests. But a lot of them are actually specific and very detailed and require a substantial amount of time just to respond to. So just to give that initial, statutorily required response to the FOIA. So that's a big part of it. I believe strongly in transparency and having the access, particularly for our residents, obviously, who have questions about the process. But it's very time consuming for the team. The other big part that we're dealing with too, which is a little bit unique,
is on the campaign finance end. So as political activity has really been heightened over the past couple of years, we've seen a big growth in the number of candidates who do not have a waiver. So you can apply for a campaign finance reporting waiver, as you guys all know, as candidates. If you spend $1,000 or less, you're not required to continually file reports with us. We currently have over 60 open campaign committees without a waiver. So those committees are filing 4 reports per year, including any committee with over $1,000 in their balance required to file 4 reports, even in an off election year. So next year, we're still going to be reviewing these reports as well. And that's hundreds and hundreds of pages that we have to review for compliance. And as the increase in that demand has happened, we all are also seeing increase from the public, right, and wanting to know that information. We really took a big step forward in posting campaign finance online this year, thanks to every candidate who participated and helped us with that process. And I think that increased transparency a lot, but we're also getting a lot of questions from the public. What does this mean? What does this look like? We actually are required to review all of those reports as well. And so there's a lot of elements here that are coming together that we just recognize our team needs additional support in order to offer that customer service essentially to our voters. And I'm pretty strongly convinced of that. We're seeing about 200 hours of overtime this year for the election division, which is 2 full-time employees and an intern. So that's a substantial number. And I don't necessarily see that going away. We're obviously kind of literally coming into that 2024 election cycle. And as a department head, that has me concerned that we just need the resources to do that. So definitely happy to answer any questions.
Justin, if I may, on your FOIA request, and I should know this, okay, so I apologize ahead of time. When you have a FOIA request, what's the fee for that?
It's a great question. So we are required by law to charge, we charge the fee based on the lowest paid employee who can handle the request, whatever that may be. So currently that's our election assistant position. Simone Johnson in our office does a phenomenal job in responding to that. A lot of FOIA requests, though, if it's under $50, a lot of times we'll respond to that for free. We utilize the county's FOIA portal, which is an online request system. So our goal is not to charge for something that's simple and that we can respond to quickly. But if it's over $50, we do charge for it. Obviously, it's taxpayer money, particularly for requests that are not even coming from taxpayers. That's a concern that I have. If a non-tax-paying person from the other side of the state or from another state is requesting information from us, we need to reimburse our taxpayers for that time. And so we're required to send a deposit letter, which actually requires us to initially estimate cost. So we do an estimate of cost based on what they request, submit that letter to them, and they need to pay 50% of that cost before the FOIA is fulfilled. One of the challenges we run into is the documentation needed to adequately respond in that initial letter takes time. I mean, we received a request, a 39-point request for information from our office that asked for the request to be itemized based on each individual item. And that took, 3 hours to compile that information just to submit the deposit letter. So this is, again, an out-of-state FOIA request that we likely will not ever see a deposit from. But that was 3 hours, one FOIA that represented 3 hours of time just to legally respond. And so,
how do you adjust your fee for service?
Well, the statute on FOIA is pretty clear with what we can. So, I mean, we have to base it on that lowest paid employee's salary and benefits. So we really don't have an option to adjust our fee based on, whether it's coming from a resident, whether it's taking more or less time. Obviously, it's based on the time of that employee.
With the example you just gave, when you send out that deposit letter, do you figure the 3 hours it took you to get to that point included in with that?
We do, and we can, but we can on the back end essentially, but ultimately we're required by law to send that letter irregardless within 5 days. So we have to respond within 5 days. We can ask for an extension of up to 10 days. And then we have some room and we're doing this frequently as well. We can respond within that 5 days and say, well, we only have this much time that we can devote to working on it during the next few weeks. We have a little event coming up called an election. It's in 21 days. We're focusing on delivering quality service to our 220,000 voters on election day. But obviously that does, the importance of transparency is huge. We have to be able to and want to be able to make sure that people have the information they need from us. It's just the challenge of delivering that.
So Justin, what percentage would you say of those responses that you've made actually then respond and pay the 50%?
That's a good question. I could get that number for you. I would probably say somewhere in the neighborhood of 25–30% do respond back and either pay in full or deposit.
So the other 75% are stiff. We're stiff to it, right?
Correct. So
we're paying for a lot of time.
Yeah, I mean,
We have to.
like in the estimation phase, so that estimate, for example, that I was talking about, that took about, roughly 3 hours of time to figure that out. The actual producing of the information would have taken, probably 100 hours, because it involves, photocopying of every poll book or, whatever information we need to provide. That isn't time invested until we have the deposit. That makes sense. So we don't do that until we actually get a good faith deposit from the requester.
Any other questions for Justin? Thank you, sir.
Thank you, guys.
All in favor, say aye.
Aye.
All opposed, same sign, motion passes. In a motion for the Ottawa County Classification and Compensation Studies Appeal.
So moved.
Support? I'm sorry. Goes in there. Marcy.
Morning.
We had to wake Mr. DeYoung up from there.
I dozed off.
Glad he's listening now, right? Just wanted to go over the classification and compensation wage study appeals. We worked with Municipal Consulting Services. Mark Notley is the owner of that group, to do a comprehensive wage study for the entire county. The effects of the wage study went in at the beginning of the year. We have, in my history here in the 14 years that I've been here, we've done 2 internal wage studies and 1 external wage study. Really, after the 2 internal wage studies, really looked to, there's so much emotion involved in a wage study. We're talking about people's job descriptions. We're talking about their salary, their livelihood. And we're looking at the job, not the person, which is just a very difficult thing to do just in general. So this time around, we did hire a consultant, about a 1.5 year study, worked with Mr. Notley of Municipal Consulting Services, and we started the wage study out at 130 different positions countywide. And by the time we finished the study, we'd probably added about an extra 20, just because we add them here at Finance. Of those 150 positions, we had 30 appeals countywide. Those 30 appeals went back to Mr. Notley for review. And of those 30 appeals, 10 were approved. So we're bringing those 10 appeals forward today. Those 10 appeals that are coming forward are appeals that are not retroactive. we did, in the wage study, we did move to a whole new scale. And when we moved to that new scale, we took where everybody was on the old scales. And we moved everybody to a comprehensive one minus our 312 arbitration groups in the sheriff's office. When we did this, we made sure everybody received an increase to go to the new scale. So there was nobody starting out the new year that wasn't going to go to an increase that stayed on the scales beside redlined position. What happens with a redline position is we do not take the salary away. We freeze the salary where it's at until the steps catch up to it. And that was the one that the Honorable Chief Judge was talking about earlier. That, excuse me, that position was a redlined position. And so what happens is as the normal 2% come in, you hold it till it catches up. That position was appealed, the appeal was denied, and that position will catch up on the new year and be right in line with the rest of the steps that the wage study appeal put it at. So we have asked to go to moving forward on these 10 positions that we're asking for approval on, not doing retroactivity because everybody's coming on at different levels. And that was something that was relayed to all departments ahead of time, that is not retroactive, that we would put these people on the scale where they're at now moving forward, because it's also dependent on employees' position dates with the county. I think that was everything I wanted to cover on the appeals themselves.
Questions?
So what do we do about the judge's request for step up from grade, what grade 5 to 7? Something like that.
I think one thing and respectfully to consider is that this wage study was done with 150 positions countywide. And I think if the whole point of having an expert come in and do that, again, I said it takes some of the emotion out of it. It still does exist. But he classified all these jobs and he classified them and they affect one another. So if we are to make changes ourselves, one, I would say that he's an expert in the area. I would say that other people are not necessarily experts in the area. I'm not necessarily an expert, probably a little bit closer, but I would say the other thing we have to take into effect is that if we allow one to go through that's different, then we also have to look at what the effect of that. So for example, that position is a clerk position in the circuit court. We also have those in district court. We also have them in the sheriff's office. We also have them in the clerk's office, I believe in the prosecutor's office. And so again, if we start making changes to that, I think we are taking the integrity of the study and removing it. And again, being respectful of the fact that I understand that there's a lot of emotion also wrapped around this.
Marcy, you mentioned the circuit court clerk position was redlined in the wage study.
That is correct.
Does that mean that the consultant looked at similar positions in other courts or other counties and that the wages here were higher than those comparable positions elsewhere? Is that what that means?
The study looks at both internal and external comparability.
Marcy, with the redlined positions in the courts, how long are they going to be redlined?
This position in particular, I took a look at. This position actually unredlines with the 2% that comes in 2023. So
going forward, they would at least get
they'll be on the scale now at the top step of that level and will continue moving forward with the rest of the group.
Okay.
And again, we don't move them back.
Right.
And at the same time, we can't continue to go COLAs because it just continues to keep it out of line.
Yeah. You know, if all of the positions were that way or that.
A few of them so we had a handful of redlined positions. We had two people that we had two positions that had long-term retirements that left the county. And so we were able to put them right back on the scale. That's already taken place this year. And I don't believe it's for the wage side, they were retirements. And then we had a few positions that just giving the 2% caught those up too. And I think there might be a handful still remaining, but this is one of the last ones that's going to catch up here.
I think it was fair to say that when the wage study was done, there were a handful of positions that were redlined. And there were a handful that were green line, meaning they were below the comps and we had to make adjustments. I think it's fair to say the vast majority fell within the internal and external comps. So those would be neither redlined or green lined.
Questions?
I might be able to add
some. Go ahead.
Are you all set with me?
Yeah, thanks, Mercy.
With respect to the circuit court clerk position, my name is Susan Franklin, I'm the circuit court administrator. We had submitted the appeal to Mr. Notley, who did the initial consultation. And his appeal in responding, or his response to our appeal, specifically stated that these circuit court clerks are not serving as the judicial assistants to the judges, which is not true. They are, as Judge Van Allsburg previously stated, and that they're not doing court recording work, which they are also doing. So I think, unfortunately, there's a misunderstanding with Mr. Notley as to what this position is particularly doing, which has caused this mistake to be made in where it's classified, which is why we've continued to try to bring this to Mr. Notley's attention. So that's, I believe, where the initial issue has been created and is why we've continued to seek that this position be reclassified.
Okay, thank you. Questions? All in favor, say aye. Aye. All opposed, same sign. Motion passes. Need a motion for the inflation impact payment.
So moved.
So, Mr. Chair, we presented last month a budget that reflected a 2% increase in employees' wages, cost of living increase for the employees' wages. And that's also the same amount that's in our union contracts. So we have 7 union contracts. 1 is up at the end of this year. The other 6 are up at the end of next year. And those 6 contain a 2% wage increase. And that's what we put in there. I believe it was comments from some of the board members, either at the board meeting or last month's finance committee meeting, or both, that expressed concern about that and said, would like staff to take another look at that in light of the current inflationary environment that we're in. So Marcy, Karen, and I took a look at that at the request of the board and came up with some options that you're free to consider. The one thing we really wanted to do was, if we were going to do some type of additional payment in response to inflation, we wanted to make it a one-time only payment that would not count against an employee's base wage, because that represents a permanent increase to our budget. And we don't know what the economic outlook will look like a year from now, 2 years from now, 5 years from now. So we were trying to balance the board's concerns about the current inflationary environment, and also being able to be fiscally responsible about it. So we presented some options here that you're free to consider or not. In essence, looking at a one-time payment of either $3,000, $4,000, or $5,000 to a full-time benefited employee. And in round numbers, a $3,000 payment will cost about $3.1 million. A $4,000 payment will cost about $4.1 million, and a $5,000 one-time payment will cost about $5.1 million. And then if there's a part-time benefit employee, that's the equivalent of a 0.6 FTE, they would get 60% of whatever amount. And then a part-time non-benefit employee would get a one-time $1,000 payment, flat fee. The idea is this would come out of our ARPA funds, if you will, and we converted our ARPA funds to lost revenue savings, so it would come out of that. So if we were to do that, obviously we've got, we received about 57 million in ARPA funds. This would come out of that 57 million. So if you approve the $5,000 payment at $5.1 million, $5.1 million would come out of that and not be available for other projects, whether county projects or any other projects for that matter. This, I would not categorize this as a retention payment unless you looked at making this payment, activate this payment, say 6, 9, 12 months from now. If you were to say, we want to do a payment and we want it to go out next month, you're not buying any retention, if you will, from the employees, because there's no guarantee an employee would be paid this and then next week say I'm retiring or going to another job. So it's not listed as a retention payment because it's not designed for that. It's really in response to the board members' comments about the current inflationary environment that we're in. If you wanted to have more of a characteristic of a retention payment, then would, to me, would have to be something that would be paid out, you know, in the next 6, 9, or 12 months, that people would say, hey, I'm going to stay here. So that this is just a series of options that Marcy, Karen, and I put together, and again, at the request of some of the board members, and would welcome your feedback on that.
Couple quick questions. Whatever we decide, we don't have to pay pension on it, correct?
That is correct.
Okay, just the FIC, Medicare, yes, and that, okay. The other thing is if we decide to do something, do we specify a date that all employees that are employed as of December 15 get a check 2 weeks later, or?
Well, I mean,
Or
you probably should, or because you're right, this says it's for any employee. And so the other thing here is someone could start and on a week before that date, and they would be eligible for that under this, you know, so there's, you have that, and then you have the other end is someone could take it and then leave the county a week later too. So that's.
or retire.
Yep.
2 weeks before the date, and they don't get the payment, even though they spent 40 years here.
Right. So yeah, so there's, and there's no way to this that I see around that. So whatever date you pick is that could happen. So yeah, you can specify a date both as to who has to be on the payroll at that point, and or whether, if you want to do this, are you doing it now or are you doing it further in the future to, you know, have it take on more of the flavor of a retention payment than this. But just so you know, this would come out of that 57 million. So what if you choose one of these options, that's less money for those 5 buckets that we've already approved for that. So just you know, just so that you're aware of that, that's where we're proposing to pay that.
Yeah, just want to explore that last sentence. Karen, if eligible and available, the inflationary impact payment will be paid by grant funds dedicated to staff wages. What is the likelihood of that? I mean, John just talked about that, you know, the way he sees it would come from the board, kind of ARPA money. But what are the possibilities of finding alternative funding for this, whether it's grants or whether it's general fund funding?
It's probably, well, it's early in the year. So last year when we did that incentive payment, we had accumulated some vacancy savings that we did use. Obviously, you know, it's early October. There's not a significant amount of vacancy savings that we can apply, or that we know that we have to apply to this. There is the possibility of some grants. We added that language because we were unsure of the amount, so it was hard to do the evaluation of how many grants would be available. I know that CMH was a significant portion of that, and with their Medicaid, and I know that there's concerns about fiscal year 23, and that they do not believe there is Medicaid dollars available, so that would be a very large that would be one of the places that we would look at to see if they could fund it. But there are some potentially still that we haven't had the conversation with, but I wouldn't think it would be a significant number.
So whether it's grant funds or whether it's alternative savings within the general fund, you're not looking at a big dollar amount.
No, it would be grant funds. There really are not significant savings in the general fund, 15 days
15 days into
into
the
the
fiscal
fiscal
year.
year.
The other thing, just, and this is getting a little bit into the weeds, but and I'm using the term ARPA funds, but as you guys recall, we were taking the ARPA funds, and one of the eligible uses for that is to reimburse us for lost revenue. And we've been in the process of taking those ARPA funds, spending it on reimbursing ourselves for lost revenue, and then taking that savings and setting it aside for the bucket projects. So we've been able to do that for calendar years 2020 and 2021. And just to give you a sense here, we're in the process of having about right now 39 million or so in lost revenue savings. We'll calculate more after the end of this calendar year. Now, we've already had an ARPA task force meeting that is considering recommending certain applications. And so just so you're aware, we've spent some of the ARPA money on the loyalty payments we did earlier this year, I think in April. We've spent some of it on the bucket manager contracts and on the eviction diversion and 2 of those affordable housing projects. And if the board were to say, hey, we'll do the $5,000 payment, and we like all the projects we've heard so far at the ARPA task force, we'd have about $9.8 million left over until such time that we can calculate more lost revenue savings. So I'm trying to give you a sense of, we've spent some of the ARPA funds already on affordable housing and eviction diversion and bucket manager contracts. And there'll be some other, obviously, the ARPA task force has met already last week, and we'll be meeting again to go over some certain projects. And we're also currently reviewing applications under the county bucket. We also have the broadband bucket. So just wanted to, that 57 million, as we're converting that into lost revenue savings, that happens over a period of, I think, 3 years or so. So we don't have all of that converted yet, where we can then extend the deadline timeline as to how we spend that money and so forth. So I just wanted you to be aware of that as well. That's fair.
Greg?
Yeah, thank you, Mr. Chair. I'm very passionate about this. Read everywhere where inflation is, and it's the report here says, we talked about in August it was 8.3. Now we're already into October. A lot of people are talking 8.9, maybe 9% cost of living adjustments here, or inflationary adjustments. Recently, it was announced that Social Security is going to go up 8.9%. MLive reported yesterday that Michigan Bridge cards are going to go up 12.9%. Over the years, we've all bragged about that we're the best run county in the state of Michigan. And many of us, if not all of us, have talked about how proud we are of the employees of Ottawa County. And I hope that our board takes this real seriously and appreciates as much as I do, and I think you do, the employees of Ottawa County. And I think right now it's time that we, again, make our walk and our talk the same and step up on this thing. And take care of the employees the very, very best we can. There's also rumors that maybe next year that maybe there'll be some other decisions made, and maybe this money is suggested to go back to Washington, D.C. and to other places. And it would break my heart if this money was sent back to Washington and we did not take care of our Ottawa County employees. My vote, my suggestion is the full amount of $5,000.
Thank you, Greg. Roger, your thoughts?
I guess I would agree that if we're going to do one of these payments, we need to do the 5,000, and I think we ought to make it effective as of November 1st, the closest payroll after November 1st.
Doug?
No, I agree with both gentlemen. I do think that there's, well, I guess the question is there some danger that someone works here for a week, takes the 5,000 and we don't see that person? That would be my concern.
I don't know if I heard you. Can you say that again, Doug?
Well, I mean, you had talked about spreading it out as a retention, possibly
option,
as an option, which would kind of ameliorate that idea, right? Where someone comes on board and it's like, wow, and then I go to another place with my 5,000. How likely is that scenario?
It could, but
Yeah, I don't know. I mean, we had some, I believe some employees that retired or moved on soon after the loyalty payment was issued earlier this year. I don't see a mass exodus, but I just wanted to say that this is not a retention. It's not designed that way, because if this were to go where we pay this in November, for example, it's buying you 1 month of retention for $5.1 million. So it's not if you're thinking this is a retention, I would respectfully disagree. It's really more in response to the board's comments about the current inflationary environment.
Right.
And so I just wanted you to be aware of that.
Right.
Bill?
I'm good with 5 moving on to the full board.
Okay. Quick question, John. Whatever amount we decide, how is that applied towards elected officials?
So what I talked to Doug Van Essen about this would apply to all employees, including elected officials. They can decide if they want to take that or not. The intent here was this would not apply to the Board of Commissioners.
I would like to amend the motion then to,
Oh,
Just to make
oh,
it,
yeah.
it's in the motion,
Yeah.
but just to make it very clear, no seasonal employees. And it would be 1,000 for non-benefited, just a straight payment of that is what we're recommending.
Marcy, an effective date that you would suggest?
We can do whatever. you
payroll closest to
decide.
November 1st.
What we could, I apologize. We could even do all employees that were currently employed as of, because this would go to the board meeting next week, Tuesday. Everybody that's currently employed as of next week, Tuesday would receive this. You may have a handful of people that start after that, but they have, that way, I don't know that anybody's gonna go through our entire process and we're gonna get them on quick enough. Maybe they come on and they like it here. So we got lots of openings, but you pick a date, maybe do anybody employed as of the board meeting date. And then what we'll do is we'll wrap that around, and they still need to be here when we pay it out, and we'll do it. You would say the first payroll.
Marcy, could we go in the
that hits
past
November.
with the date or no?
I'm sorry,
Could we go in the past with that date?
it's a little bit more difficult to do just because each payroll, we have hundreds of changes to each payroll. So keeping track of it. Our payroll team's running this week's payroll right now. We could take everybody that's currently on this payroll. That would be
If you go,
easier.
if you go in the past, it's less likely to be eligible for federal grants.
Yes, that is.
Okay,
I think it would just be a date specific.
Okay.
Sooner than later.
Roger, you had
Yeah, I want to amend the motions to put a date on it, and as of the commission meeting and the end of this month.
Okay.
You do that.
I think it's the committee's opinion that we should recommend the $1,000 payment to.
Correct.
Correct.
do we want to discuss because I was not aware that elected officials would be eligible. We want to discuss.
Doug Van Essen had indicated because it's a one-time payment, so it would not, just like everyone else, it would not count towards their permanent salary. So if an elected official is making 100,000 a year, and they get 5,000 here, their future salary isn't 105,000, it's 100,000. So that was the opinion that we received from Doug Van Essen as well.
But I mean, is everybody okay with elected officials minus the board receiving the 5,000 as well?
Yeah.
They can always give it back.
Yeah.
True. True.
They can.
They can do anything with that money.
I guess I question it too.
Just a little bit, but it's- I don't.
They're elected officials. Yeah.
You're right, Joe. They are affected by inflation like anybody else.
Yeah, Justin and Joe and Lee don't go to the grocery store and, oh, you're an elected official, so we take 15% off your grocery bill.
True. True. That is true. There is no elected official discount card
Okay.
for sure.
All right.
At least not that we know of. I don't
Um,
have one. If you guys have got one, I'd like to know about it, but.
And again, the intent was not to have it apply to the board.
Right. So
No,
just do that.
shouldn't be self-serving, absolutely.
So
I guess I would just like to, make a motion to exclude elected officials and just see where we are on that.
I'd say just give them the option of getting it back. It's up to them.
in my conversations with them, I let them know that they would be eligible per Doug Van Essen's opinion, and that they could individually choose to accept it or not. That's how I left it with them. Assuming that the board approved it. If the board says otherwise, then it's what.
I guess when we vote as a commission, I think that needs to be brought up.
Yeah, I'm good with that. Any other comments? All in favor of the motion, say aye.
Aye.
All opposed?
Leave it up to them, Doug.
All right, fair enough.
Motion passes. Need a motion for the document imaging system contract.
moved.
Good morning.
Morning. I just wanted to provide a little bit of clarification on this, just because there's been some changes with the company that sends the invoice out. Their accounting system's different now. So they used to send one invoice, which included Highland Software, which is the maker of the software you're seeing on what's up for approval right now. They also provide their own proprietary software, which is a separate invoice from this, and then another invoice. So based on those changes, this is one of 3 invoices, but I believe this is the only one that would be up for approval in this process.
Aaron, you may want to just give a brief description of what this system does.
Oh, sure. OnBase is the document imaging system for the county. So a lot of the court processes processed through the sheriff's department, and it's really used almost all throughout the county. I believe 20 of the 33 departments use OnBase. So it's got a broad range of use. With this invoice that you're seeing here, there's some also added capabilities that we didn't have last year. So those would be some of the changes that we're seeing with how they're doing their accounting now. Move from annual maintenance process to what's more referred to as like a subscription-based software. So rather than buying it and then having the software, it's like we're renting the software. So.
Any questions? Thank you much.
Thanks.
All in favor, say aye. Aye. All opposed, same sign. Motion passes. Need a motion for the fiscal year 2022 budget adjustment.
So moved.
Of course.
Aaron, anything?
So yes, so this is the first month you'll see both 2022 budget adjustments and 2023 budget adjustments. The 2022, we're really closing out the year. You're seeing some final adjustments for things that were in progress. One of which is the witness fees, the expert witness fees. So if you recall, back in April, the board approved $141,000 budget adjustment for the prosecuting attorney to hire an expert witness. That as it progressed, that process included some additional charges. And that estimate that we did in April was insufficient. So this particular month, we have a $45,000 request to reallocate additional funds to finalize that service. In addition to that, we have the debt service fund. We budget for our debt service every year and plan as another example. And the energy bonds that were issued in 2013 receive a federal subsidy. As I understand it, when the federal budget is not adopted, they can send us a little bit less. We never know what that amount is. So we're making that adjustment to close fiscal year 22. There's a couple other adjustments in 22, mostly just closing out the year. The medical examiner has staffing to investigate crashes and deaths. And so when those things occur, we have to fund those. And so we're looking at the medical examiner's budget. And then 23, most of those are getting grants set up and rolled over so business can begin for 23. And those are more standard budget adjustments that you traditionally are used to seeing. The COVID grants, we did not include an estimate for public health for the COVID grants that they receive. And so what you're seeing here is what we have right now on hand. So we didn't include an estimate because when we were doing the budget prep, we were unsure of those amounts.
Questions for Karen? Doug?
Yeah, just a couple of questions. One is, if you could just discuss the tower fund real quick. And then I guess going to the expert witness, that's for the one contract, not for the fire, it's for the.
Correct, it's for the contract, the Karen Bose.
Right, but I mean, we have two expert witness contracts. That is, one is for the testimony and then is for the fire, right?
Yeah, Lee, did you wanna?
I think I can help you out with that.
Yeah, thanks, I appreciate that.
We actually don't have a contract with this expert witness.
Okay.
That's one of the issues.
Okay,
This additional that we're requesting, yes, you're right. We do have two experts. One is on the fire science and then one is on the false confession is what they're calling it. So yeah, we do have two different experts, but no contract with the one on the false confessions. It's a group called the Wellner Group.
right,
That did the report on that. And, you know, I can sort of give you a little history here. When we came to the board back in April and asked for $140,000, that was based on estimates that they had given us.
right,
And we had formulated that amount and came to you and asked for that. And we had also responded back to them saying, okay, this is what we're coming up with. Does this look right to you guys? And they
Right.
said, yes.
okay,
So we received a total of 5 invoices from them totaling
Okay.
about $136,000, which we were good. And we thought we were at the end of it. And that was in May. And then in July, we received another invoice from them after we had received their final report that we're going to use in court.
okay,
So I was somewhat shocked to see this last
Okay.
invoice for $64,000, almost $65,000. Because that would put us way over the 140,000. So my initial knee-jerk response was, we're not paying this,
right,
you know, because we relied on their estimates. But on further reflection, and after talking with the Wellner Group and after talking with some people in administration who gave me some good advice,
Yeah.
they said, well, you may not want to cut off this relationship with these people because you may need them in court down the road. And if we cut off that relationship, we may have wasted the $140,000 we've already spent.
Mhm.
So it was suggested that I call this Dr. Wellner who runs the Wellner Group and see if I could talk to him a little bit about the bill and try to find out why we got this extra bill and whether I could talk him down at all.
Mhm.
So I did that and I talked to him on September 23rd. And he did agree to knock $15,000 off of that bill,
okay,
which takes us down to this 45,194
Okay.
figure. Actually, it's 49, but we still had a little bit left over from the previous 140 that was approved. So he did agree to do that. And I was not in a position to make an agreement with him because I had to bring it to you first for approval. I can recommend that we accept his offer.
But I couldn't make an agreement on behalf of the county without running it past you first. So he agreed to take $15,000 off that $65,000 bill. Also, moving forward, he's agreed to provide services that would total approximately somewhere between $15,000 and $20,000 at no additional cost to us as we move forward if we need to prepare for trial. And he would help us prepare for that, for motions and trials. So there would be no additional bill for that. Now, there still would be possible additional bills if they have to send an expert to testify in court, and the price for that was going to be $7,000 a day. That's, you know, they had told us that from the beginning. He agreed to cut that down to $5,500 a day moving forward. He did indicate to me that the reason for the additional invoice was their expert that they had working on this false confession issue spent a lot more time that was not anticipated doing research, given the vast amount of resources out there to research, spent more time, more hours researching this than they had originally anticipated. That was his explanation to me. He didn't indicate to me, however, that they are very invested in this project, as are we financially, but they're invested in it because of the work they've done and the belief that they're right about what they're doing, and they want to see it through. And that's why he agreed to, he would like to maintain the relationship, because I called him at first to challenge him, like, what's going on here? But they would like to stay with it, stick with it, finish it through, provide testimony if needed, not sever our relationship. And that's why he agreed to reduce the bill, and also agreed to reduce the rate going forward and provide some of the services that we would have been billed for in the future. He's not going to bill us for those.
Okay.
So that's where we're at right now. And I talked to John about this previously, and he asked me, well, would you recommend that we accept this offer to reduce the invoice and going forward? And I said, yeah, I would recommend that we accept it.
Right, I appreciate that, and I definitely appreciate the position you're in,
Will
so.
there be a contract written up, Lee?
No, I don't believe there is a contract. We've never
So
entered into a contract.
So it's his word against yours?
Well, we've got it all documented. I mean,
Right.
there's a long version of this. It's all documented in emails and letters. Yeah.
That was kind of my question, so.
Yeah.
I think your agreement with these extra services and the reduction in the fee is all in emails. It's in written
Yes.
form.
Yes.
Just that answer.
And I just wasn't in a position to say to him, or we're accepting. I have to run it past you first.
Okay, any other questions for Lee? Thanks, Lee.
All right, thank you.
Anything else on budget adjustments? All in favor, say aye. Aye. All opposed, same sign.
Aye.
Motion passes. Discussion items. Amanda's not available. I talked to her yesterday. I guess she had surgery last week, so she said if anyone has questions to feel free to reach out to her by email. So. And then the other discussion item here is severance agreement for department directors.
I think this was brought up at the request, I believe, of Doug, if I'm not
Right,
mistaken.
right. Well, I think Greg and I had a discussion, just kind of like looking at what we've done recently with the health director, with the DEI director, with, you know, your deputy, and how we can make that a more consistent approach to severance, right? So I think from my point, I definitely am in favor of applying this across department head level. I personally am in favor of, you know, going a little bit deeper to deputy level, and, you know, even to some measure to every employee, right? I think that this is, you know, for me, a $0 assurance policy for our employees, right? I mean, we're not in the business of firing folks for no reason. So, you know, in an ideal world, none of these severance agreements would ever come into play, right? If we don't do that. But at the same time, we'll provide insurance. And I think Doug mentioned this last time, and I was hoping he would be here, just kind of talk about that aspect of it. You know, just about the legal aspect of, you know, employees in the future making claims against the county. If we had a universal and severance, you know, package for all employees, I think, you know, and maybe Doug will dispute this, but maybe, you know, I think we would have a much clearer legal situation, right? Where we don't have a year to dispute with a fired employee, right? Because we had the severance agreement in place ahead of time. So Those are kind of just my, basic thoughts, 3 months for directors, 2 months for deputies, and then 1 month for all employees.
Comments?
Yes, I like consistency also. I really do. I know we've done a couple of these now for, I think, 2 directors and I'd like to be fair and consistent with kind of protecting other people in the organization. If they're let go for any just for any reason that's, other than, stealing or something like that. But I think if we do it for a couple department directors, I think we should be fair and equitable for other directors.
Yeah, I don't have a problem with it. I just. It kind of gets you on a slippery slope.
I mean, everything we do gets us on a slippery slope, though. I mean, we just allocated, in theory, $5 million for bonuses. And if inflation is again 8% next year, we can do the same thing. I mean, there's always a slippery slope for every action. Was that?
I said, that's up to the next board.
Right. But I mean, with every action, whether it's this board, next board, I mean, you can always say, what about the next time, right? But
Are there any counties that you know of that?
Not off the top. I've never heard of a county or a city providing severance agreements for every employee. I've never heard it. I would be surprised if anyone does do that.
Yeah.
I would like to have it and maybe continue this discussion maybe when Doug is here on some of the I can't answer legal questions. But I do have some reservations about this because, with an organization of 1,200 people, unfortunately, not everyone works out and
Right.
Marcy can say this better than I can, that they have to go and deal with employees where we've fired employees and that was the end of it. The reason that we looked at doing this for the health officer and the DEI director were really based on some, electoral consequences or statements that were made about those 2 offices that were not made with respect to fiscal services or IT or equalization or any of the other departments. And so I while I can look and see if other counties do this for directors, I'm very confident they don't do it for all employees. I would be pretty surprised if many of them did it even for department directors. And so I can't answer some of your legal questions or comments that, if we can have this discussion maybe at the following meeting as well with Doug present. But I have some reservations about this.
right, I guess, one of what Craig says about consistency also applies to what you're saying about electoral, possibilities. We just don't know which departments, may be a hot department, right? I mean, equalization, we don't know. I mean, could be. I mean, more likely that maybe a court, I'm just saying there are departments that we don't think of as, particularly on the hot seat, but they could be, and we just don't know what that would be, and we can't predict the future, right? So why not have a consistent approach to how we do a severance? I mean, if it's just at the director level, it's just at the director level for the time being, but at least then we have a consistent policy for, our directors. And, when we're not trying to predict the future, which department is going to be on the hot seat, which departments are not going to be on the hot seat, which seems like we can't predict the future. So why should we? We just say, here's a consistent policy for every director.
Yeah. And we've handled some of these in the past with directors on a case by case basis. So I think, again, in some respects, I know we've let go of people without any severance, and other cases, it wasn't working out, and we put together a small severance package for someone as well. And we've looked at those on a case by case basis. But
I think I would like to just ask John, to take a look at it and talk, look at, what other municipalities might be doing, and also ask Doug about it.
Yeah, I'd like to see the legal.
Yeah.
Or at least how Doug would propose to write it up.
okay, I can do that.
Because I remember, serving on Grand Haven City Council, and we we, our city manager certainly, let some department directors go because of what they were doing, and there was no severance. And that was his responsibility. It wasn't our responsibility as council members. It was the city manager's responsibility. And in your situation, it's your responsibility. It's not our responsibility. And so a future commission really doesn't have the responsibility or shouldn't have the responsibility of letting department directors go. Fortunately, what's coming is, if they're certainly in the majority, they're going to put pressure on John.
Well, and I'll just respond to that. I mean, if there's whether any board said, whether it's a future board or a current board said, hey, John, you need to get rid of such and such employee. And if it's for something that's, totally illegitimate,
Right.
then
Yeah.
I'm going to just say no, and then you can deal with me.
Yeah.
Because
Right,
that is
exactly.
not the right thing to do, to just
Right.
say, well, we want that person fired because we disagreed with the decision, as opposed to,
Right.
hey, they're showing up drunk to work or something,
Yeah.
something along those lines. I mean, that's
There's
that's why I have severance, because I've got to make those decisions where a board may ask or demand that I do something, and if it's not the right thing to do, that's my protection, to be able to make those decisions and say,
Correct.
no, we're not going to get rid of such and such director just because you didn't like the report they issue. And then if they don't like that decision, they deal with me. And that's hopefully the level of protection that I can provide to the department directors and the employees below that, so that they don't have that kind of interference from whether it's this board or a future board.
And that's why I think you gotta do it one at a time. I don't think you can have I don't think 3 months. I think you do a blanket, because, we did 3 months with the health department because that was the end of a retirement. If it would have been 4.5, we probably would have did 4.5. So I think you gotta do it one at a time. That's my opinion on that.
But I can ask Doug to look at, and we can bring this back for discussion.
All right.
Yeah, because, where do you set the threshold? I mean, it's, we could say, Marcy has to go because she's got a Michigan State lanyard on.
That's true.
But that's justified. I mean, that's just kidding.
But I mean, that's, you gotta have.
I think Roger's point with, and John talking about, it's your decision with your severance. I think that makes a lot of sense.
So, but I'll have Doug, I'll look into legalities and
I appreciate
bring
that.
back up.
Thank you.
Anything else as far as discussion items? Second opportunity for public comment. Any public comment? Wise words from Michael today.
As you know, I mainly listen. This is Michael Curtis, Spring Lake Township. Listen, I'd like to provide one bit of feedback to Phil in particular in terms of consistency. The board does have a consistent policy with respect to remuneration for its employees. And we heard a lot of discussion about adjusting that consistent policy today. And I think that same attitude should be brought to the question of a severance package for employees. It ought to be consistent across the county's population of employees. I think that's an important step to take, to broaden that sense of consistency that the board is already following. And just to extend it to the last step of the relationship between an employee and the county. Thank you.
Thank you, Michael. Any other public comment? Seeing none, entertain a motion to adjourn. Or, all in favor, say aye.
Aye.
Aye. We are adjourned.